Taking on the role of an executor, well, it's not just a task. It's a huge responsibility that can shape the legacy of your loved one. So if you're handling a loved one's estate, it can be one of the most challenging, emotionally taxing responsibilities you're ever going to face. I've done it. It's not great. But as the executor, you're not just handling the paperwork, guys. You're going to navigate tons of things. You've got legal obligations and financial intricacies and emotional dynamics. There's a lot of that. Now, this role demands precision, empathy, deep understanding of the boundaries set by the law in your state. Because missteps in this crucial role can lead to devastating legal battles. I've seen it. Significant financial penalties and irreparable damage to family relationships. That happens in, I think, over 50% of them. So do you get how important this role is? Let's get things straight here. As you know, I'm a straight shooter. I'm going to explain the critical do's and don'ts of being an executor and equip you with the knowledge because you want to honor your loved one's legacy, right? You want to protect also your own peace of mind at the same time. It's challenging. So Diane Cardano here to get through this executor duties, pluses and minuses and everything. And remember, if you like this going on, I've got other videos about probate here as well. So check out my channel and also subscribe. And let me break it down, because exactly what you can and cannot do as an executor during the probate sale. And ensure that you can handle this critical role, or don't do it. Because if you don't have confidence and clarity, you need to give it out to somebody else. Now, I was the executor for my mom's estate, and I was really worried the entire time that I was doing everything correctly. And I did most of it without an attorney. I knew enough to make me dangerous, but I did have an attorney helping me. I learned a lot as well, so I can share it with my clients. And my siblings, they trusted me throughout the process, and I included them all along the way, exactly what I was doing. And I'm in Pennsylvania here, so today I'm going to talk about probate sales in Pennsylvania, specifically the things that an executor can and cannot do. It's pretty much the same in any state, but in our area, specifically Philly and the burbs, probate sales are a common way to settle estates, probably in your state as well. So if you understand your role as the executor here, you can help ensure a smooth and efficient process for everyone involved. Now let's understand this, that being named executor in someone's will is a huge honor. It shows the trust that the deceased had in you to handle their final affairs. But before you jump into it, there's some limitations you need to understand. First things first, you can't actually do anything until the court, or rather the Register of Wills in your town, officially appoints you to be the executor, names you as such. This process is called granting letters testamentary and can take weeks and even months. Now in the meantime, the estate might be vulnerable. So if you're in Philadelphia or the surrounding counties, a specific fact, according to local legal professionals that I know and being through the process, the average wait time for granting letters testimony in Philadelphia and the burbs can be anywhere between 4 to 6 weeks, depending on the complexity of the estate. Now, the waiting period, it's frustrating as heck, especially if the estate has assets that need immediate attention, like a house or whatever. So what can you do in the meantime? My advice is contact a probate attorney right away, or read up on this. Maybe you can do this without an attorney. I have a great attorney I just used for our nephew's estate. I was helping my niece handle her father's estate, and he advised our family on securing the estate while we waited for the register's approval. Now, an attorney can also help you understand your official duties and limitations once you're appointed, to get all that out of the way while you're waiting those 4 to 6 weeks. Now, in Pennsylvania, an executor has several fiduciary duties and responsibilities to ensure the estate of the deceased is managed and settled according to the will and state laws. Very important. Because once you're officially the executor, you have a huge responsibility. A fiduciary duty to the beneficiaries, especially. This means you're legally obligated to act in their best interest always. So here are some of the key duties, and this is similar in most states. This is like a general outline. One, you want to locate and file the will. The executor must locate the deceased will and file with the local register of wills to begin the probate process. Next, notify the beneficiary and heirs. They must notify all of them named in the will about the descendant's death and the probate proceedings. Number 3, very important, is inventory and appraise the assets, because the executor is responsible for identifying and gathering and valuing all the deceased's assets. A big role, believe me, including real estate and bank accounts and stocks and bonds and personal property. It's huge. 4th thing is to pay debts and taxes. They must pay the descendants outstanding debts, bills, and taxes, ensuring all financial obligations are met before distributing the remaining assets. Like I did with my mom, I put all the money she had in a bank, I had to put it right into an estate account, and that's where we paid all the bills from. So getting your federal ID number for your estate and getting a bank account is important. Fifth thing you can do is manage the estate. During the probate process, the executor must manage and protect the estate's assets, which may include maintaining property and managing investments. It's a big one. And six, to distribute the assets, because once all the debts are paid and all the taxes are paid, the executor distributes the remaining assets to the beneficiaries according to the terms of the will. And lastly, prepare and file the final account, because finally, the executor prepares final accounting of all the estate's administration, files it with the court, closing the probate process. Now, this whole sounds really simple, but there's a lot of steps in there, especially with the assets part. And of all the steps, like I talked about, the inventory and appraisal of the assets, that's the most difficult. Now, in practice, you can't sell estate assets for less than market value without everyone's agreement. And any such agreement should be in writing to avoid future disputes. For instance, maybe you want to say a car was valued at $25,000. You can't sell it to a friend or family member for just $4,000. That would be a clear violation of your fiduciary duty. So it's important to obtain fair market value for all estate assets to ensure fair distribution to the beneficiaries, okay? You also can't change anything in the will. If you think a change is needed, discuss it with your attorney. And unfortunately, you can't stop someone from contesting the will either. That's why I surely recommend everyone to consider a living trust. A living trust can help avoid probate altogether, saving time and money for your loved ones. There's tons of positive and negatives. I'll be doing a video about that. Check it out, coming up soon. Remember though, there are consequences for mismanaging an estate. If a beneficiary believes you're not fulfilling your duties, they can petition the court for a full accounting or even have you removed as the executor. Now, this can be a lengthy and stressful process for everyone involved, so it's crucial to fulfill your responsibilities with honesty and integrity. But there are 5 consequences that I think that can arise that include legal and financial repercussions. 1, your legal liability, because beneficiaries or the heirs can sue the executor for breach of fiduciary duty. If found guilty, the executor may be held personally liable for any losses incurred due to their actions. Second thing, like I said, you can be removed from your position. The court can remove the executor from their role if it's proven, though, that they have mishandled the estate. Third thing is financial penalties. The executor may be required to reimburse the estate for any financial losses resulting from mismanagement. So make sure we don't do that. Fourth thing is maybe criminal charges. In severe cases, especially if the executor is found guilty of theft or fraud, they could face criminal charges. And lastly, your reputation damage. It could damage your reputation. The executor's personal and professional reputation, it could suffer significantly, affecting future opportunities and relationships. So since being an executor is a big job and it takes time, you don't have to go at it alone. Some resources I can help you navigate a probate sale here in the burbs, and it's similar in any state. One, again, get a probate attorney, because a good attorney can help with taxes, Social Security, and dealing with the courts in district, which can have its own specific procedures. It's like the good old boys with these attorneys. They know people, they can guide you through the complex legal issues, they can show you that you comply with all state and federal obligations and regulations. And then get a realtor. When it comes to selling a house, a real estate agent experienced in your state's probate and trust sales can be a lifesaver. Now, I've sold many probate listings, and there are many issues that come up and then arise. And I work with these executors, and it's really terrible when the siblings start fighting over the inheritance. I did do a video on that. Check it out. Now, it's crazy what people will do when money's involved, right? So what do? Hire an agent who understands and has sold many probate homes. Get their track record, find out what it is, because they know the local market, they understand the nuances of probate sales, and ensure a smooth sale, one that maximizes the value of the property. And that's, I feel, is the most important. I do that for all of our clients, no matter if it's a probate or not. All the beneficiaries. Think of all the people that you're helping out here. So there's a lot more here. I just scratched the surface and covered the basics. So the last thing I want to talk about, and make sure you know, there are many specific challenges executors face in Pennsylvania probate sales and in most states. First challenge is, and foremost, is securing the property. In Pennsylvania and in most states, it's common for family members or even strangers to try to access the deceased home right after they pass away. Now, this can lead to missing valuables or damaged property. So it's very important, and I'm sure they're not going to understand this. Like, why aren't you letting me in the house? Tell them it's a time of celebration of the person's life and unity as a family. Let's do this together. Let's go over together and do this as a group. And if someone can't be there, do it on Zoom. But it's really important to involve the whole group when you're doing this part. And then there's the emotional toll. Probate can be a stressful process. I've talked about this, especially for those grieving the loss of loved ones. Some of the siblings you have or beneficiaries can be more emotional than another. And you might find yourself overwhelmed with paperwork, legalities, and the pressure of making the important decisions. And I know that was the case when I was doing my mom's estate. And on top of that, disagreements can arise among these beneficiaries, adding another layer of stress. I've seen it in many of these sales. I think 50% of my probate sales, they have problems between the beneficiaries. And there's a huge time commitment in being an executor, because probate in Philly and the burbs here, that can take anywhere from 6 months to 2 years, depending on the complexity of the estate. So if the estate includes a business, that's a lot. That's complex, right? Or complex financial holdings, or a property that's located outside the area that you live in. The process can take even longer. So be prepared, be patient, and organized throughout the process, because some of the biggest challenges are court delays. Probate court processes can be notoriously slow, causing significant delays in the sale of estate properties. The delays can be due to backlogged court schedules or administration procedures or required court approvals for certain transactions. When it has to do with the government, there's also always, I should say, slow processes. So needless to say, that can be very frustrating for anybody, such as the beneficiaries, waiting for their inheritance, and could prolong the executor's responsibilities. So some of the things that could do that are title issues. I know the clearing of a title of a property involves ensuring there are no outstanding liens or unpaid taxes or unresolved legal disputes. I just did this with my nephew's estate. There were several liens on the property that had to be handled. And even after settling of the home, the money could not be distributed until we get a final number for this legal obligation that they had. It could complicate, delay sales sometimes. So it must be resolved to provide a clear title to the new owner. And this often requires thorough investigation and sometimes legal intervention to clear any encumbrances on the property. And then there's estate expenses. It can be very expensive. As you manage the financial aspects of an estate, it can be burdensome. Common expenses include executor fees, attorney fees, court fees, appraisal costs, surety bonds. These costs add up quickly and can consume a significant portion of the estate's value, potentially reducing the amount available for distribution to beneficiaries. So outlining all that is really important for the beneficiaries to see everything that you're doing at all times. And then there's asset management. Executors are responsible for protecting and managing estate assets until they can be distributed. That means, like for real estate properties, preventing depreciation or damage. Now, if you neglect these responsibilities, it could lead to financial losses for the estate and then legal liability for you, the executor. And then we talk about, of course, beneficiary disputes, always happening. These disputes among beneficiaries, boy, they can arise for so many different reasons. Disagreements over the valuation and the sale, whether to sell or not to sell, or perceived fairness of the asset distribution. Disputes can lead to legal challenges and further complicate the probate process. So requiring the executor to mediate it and resolve conflicts while adhering to the will's terms, it can be kind of difficult. That's why having an attorney around can help out. And lastly, just make sure you comply with the legal requirements. Executors must navigate complex legal requirements. I talked about this, which vary by jurisdiction. Failure to comply with these issues and these requirements can result in personal liability, penalties, and like I said before, removal from your position. So executors, I often see they get legal counsel to ensure they fulfill their duties correctly and avoid potential pitfalls. So how can you be a successful Pennsylvania or your state's executor? So let me finish with a couple tips for you. And you want to have a smooth process, right? So right off the bat, gather all your documents. Get them all together. Get them all uploaded, scan them, put them on the computer. The will, property deeds, financial statements. Do this as soon as possible. Create a kind of like a Google Drive or a box where all your documents are. It'll make the process much easier for you and your attorney. And start by locating the original will. And if you can't find it, you'll need to request a copy from the Register of Wills. And once you have it, compile any documents related to the estate's assets and liabilities. And be proactive. Don't wait for the court to appoint you as executor before taking steps to secure the estate. Like I said that before. While you can't take any official actions until you're appointed, there are steps you can take to prepare. Contact a probate attorney familiar with your state's procedures as soon as possible. And make sure you communicate with your beneficiaries. Keep them informed along the way. I've said this before, I'm going to say it again. Any decisions that you need to be made, let them know what's going on. It's going to help avoid conflict later. I would say schedule regular meetings with the beneficiaries to discuss the assets. Put everything up on the drive. Put a spreadsheet together, a timeline for probate. Any potential challenges that may arise. Be transparent about all your actions and decisions. Be prepared to answer their questions openly and honestly. And utilize all your resources. Remember, you're not alone. These are resources, tons of resources available online to help you navigate the probate process in your area. And in Philadelphia here in the burbs is where I'm at. So don't hesitate to reach out for assistance. You can go to the local bar associations. They have a referral service there. You can connect with a qualified probate attorney there. The Register of Wills website's really, really helpful. I've gone there before. They have fees and schedules for the fees and forms. And there's plenty of legal aid organizations if you can't afford an attorney to help you assistance here. So that's a lot. We went over a lot about this executor, so you should see how important this is. Thanks again for joining me today. I hope this information has been helpful. If you have any questions about probate sales or being an executor in PA, state of Pennsylvania here, or in your state, leave a comment below. I'd like to know what happened in an executor in your experience. Mine was really a great experience. And don't forget, like this video and subscribe to my channel for more advice here about probate. Until next time, see you later. Take care.